Today we're going to revise fiduciary duties. First of all, let's define who is a fiduciary. Fiduciary, there is no set definition, but there are a few cases that gives us guidance. If you have a problem question or an essay question on fiduciary duties, please use a legal definition and cite a case for it. Generally, fiduciary is someone who undertakes to act in relation to the property of another, and it's someone who has a responsibility of trust and confidence. The case you can cite is Bristol and West Building Society versus Matthew, where Millett LJ has defined who is a fiduciary. A fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which gives rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. So a fiduciary should have an obligation of loyalty, and if this loyalty, trust, and confidence is broken, and then fiduciary can be held liable. Example of fiduciary relationships: trustee and beneficiary, principal and agent, company and its director. All these relationships raise issues of trust and confidence, and the fiduciaries are expected to keep it that way. If they are in a position of fiduciary, they cannot make profits or they cannot benefit somehow from their position as a fiduciary. Here are the core principles that you need to remember about fiduciary duties. No profits should be made out of a fiduciary position. Fiduciary must not place himself in the duty where duty and interests conflict. So conflict of interest directly raises liability for breach of fiduciary duties. Fiduciary must not act for the benefit of a third person, only if they get a valid permission for it. So in case a situation of conflict of interest arises, there is a way to get authorization. So if it's a company director, the director will explain the opportunity and tell everything, the full disclosure to the board of directors, to the shareholders, and if the approval is given, then the transaction may go ahead without consequences. Directors must ensure that there is no direct or indirect conflict of interests. Directors, company directors must ensure that they always act in the best interest of the company. Director must not accept a benefit from a third party. If there is any possible conflict, the company must be notified. Under Companies Act 2006, as we said, if there is a situation of conflict of interest, there has to be a full disclosure and notification, and then if the authorization is given, in that case, the director can go ahead with the transaction and no consequences will be faced, such as imposition of constructive trust and breach of fiduciary duty, liability on the profits made from that opportunity. If there is a specific provision, common law overrides equity, and these duties under Companies Act are owed to the company, not to the shareholders. These are the key principles that you need to remember. So when you are dealing with fiduciary duties for the purposes of equity and trusts, you may be faced with two scenarios that can be a trustee and a beneficiary scenario, or company and the director, company and company director. So in case of company and company director, the duties are not owed to the shareholders. Shareholders are members of the company, but the company, as you know from the company law, is a separate legal entity, and the directors owe fiduciary duties to the company itself rather than the members of the company who are the shareholders. The leading case that you need to remember about fiduciary duties is Boardman versus Phipps. We have a nice short video about Boardman versus Phipps that explains the facts and the principle that came out of it, and I'd like to show that to you.
Boardman and Phipps is an equity and trust case concerning the fiduciary duties of a solicitor owed to the client. Here are the facts of the case. Boardman was a solicitor for a trust, the Phipps Family Trust. He was not a trustee, but he was in a fiduciary capacity as the advisor to the Phipps Family Trust. Boardman was aware of a large amount of commercial information about the company. This information was confidential. With a great amount of work on Boardman's part, the company generated a large profit, both for the trust and for Boardman personally. However, one of the beneficiaries learned that Boardman had taken personal profit. As a result, they sought to sue Boardman to recover the profit for the benefit of the trust. The key issue in the case was whether Boardman was entitled to keep the profits of his own shares, or was he required to hold the profits on constructive trust for the beneficiaries of the trust. It was held that Boardman should have held the profits on constructive trust for the beneficiaries of the existing trust because he was acting as a fiduciary in his capacity as a solicitor advising the trustees. As a fiduciary, he was not entitled to permit a conflict between his personal interest and his fiduciary duties.
So as you can see, the Boardman versus Phipps is the main principle where strict no profit rule was established. Well, it was established before that as well, but it was confirmed in Boardman versus Phipps, and it's one of the most important cases. Even though the fiduciary here in Boardman versus Phipps did not act dishonestly and did not make the beneficiaries lose any money, on the contrary, because of pursuing that opportunity, the fiduciary actually brought a lot of money to the trust. But still, the liability was found because strict no profit rule was applied. This basically means that even if the fiduciary acts in good faith, and even if the fiduciary, by pursuing the opportunity in question, brings a lot of money to the trust or to the company, and it's actually a good thing, they can still be held liable for making unauthorized profits because it's a strict liability. It doesn't matter if it's in good faith or if it's in bad faith. The intentions of the fiduciary does not matter. If unauthorized profits are made, strict liabilities imposed, and the fiduciary will be held accountable for the profits made, even if he did not act in bad faith. However, as you probably know, this strict no profit rule is debated. Even in the case of Boardman versus Phipps, there is a dissenting opinion, dissenting judgment of Lord Upjohn, where he argued that we should not apply strict no profit rule as a strict principle without regarding the facts. He said that first we have to consider the facts of the case. And if the facts of the case require so, only in that case we impose the strict no profit rule. But we should always consider the facts of the case first. That was an indication that, we have to consider if the fiduciary acted in good faith or bad faith before imposing the liability for breach of fiduciary duties. There's another academic journal that I suggest you read, especially if you have an essay question on this topic. It's a journal by Gareth Jones, a journal article by Gareth Jones, where he was criticizing the case of Boardman versus Phipps. He said that it was offending legal as well as common sense. He argued that the court should not apply no profit rule strictly, but first of all, carefully consider facts of each case. And most importantly, if the fiduciary acted in good faith. So he was saying that if the fiduciary acted in case of dishonest action, Jones argued that the court should consider if the fiduciary made profit at the expense of the beneficiary and if he deserved the penalty. So basically, he's saying that there are three things that the court should take into consideration: whether or not the fiduciary acted in bad faith, dishonestly, and if the fiduciary made profits at the expense of the beneficiary, and finally, if what the fiduciary did deserves a penalty. So how do you revise fiduciary duties for your equity and trust exam? You may get a problem or essay question on this. It can be either of it. I've seen many problem questions as well as essay questions. So my best advice is to have a look at your past exam papers, get both a problem question and an essay question on fiduciary duties and answer them, both of them, using hierarchy structure. You have to use your lecture slides, your lecture materials, as well as our study materials for answering the practice questions, the essay or problem questions. Your lecture slides summarize the syllabus and all the cases that you are supposed to mention, but most likely it will only be very brief and requires further research, whereas our study material summarizes for you all the further research that you're supposed to do from journal articles, from books. In some cases, you may need to look further than that, but if it's for an exam, most likely our study materials is enough, and it saves you thousands of hours in reading books and reading journal articles. So make sure that you use our study materials to save a lot of time. On the exam, you'll most likely get a very similar question than the one from past exam papers. So if you have already practiced with your past exam papers and you have drafted an answer to them, it will be very easy for you to answer your exam and get a high grade. So recommended reading, make sure you have a look at our notes and revise the topics that you're going to need for your exam using your lecture slides and our notes. It can be accessible at this link. Our example essay is very important for you to review. This is the way you're supposed to do the hierarchy structure, the way you're supposed to use your knowledge in answering problem and essay questions. Most of the students don't pay enough attention to this, and this is one of the most common reasons why students don't get high grades as they expect. So make sure that you practice and review our model essays as much as you can. Our cases is a great summary of each important case summary. So we do have cases on the notes, but it's a brief summary. The notes, we're trying to make it as condensed as possible. So if you need further information on a particular case, you can use the search bar for cases on our website and see further details on that particular case that you're interested in. Our quizzes and our flashcards are a great tool for you to practice your knowledge, especially if you're supposed to memorize some principles and case summaries because you have a timed exam. Make sure you use our quizzes and flashcards to practice your knowledge and test your knowledge. How we can help, other than the study materials that are made by top students and graduates, you can have a look at our tutoring services. Our tutor will be able to assist you for your coursework or for preparing for an exam and help you understand how you're supposed to answer problem questions, essay questions, how you should do your legal research correctly, how you should structure your answers correctly, and so on. It's a one-to-one support on a Zoom meeting from one of our tutors who will be assisting you throughout your studies with whatever you need to make sure that you get the high grades that you need. We have already helped thousands of students get high grades. 90% of our regular students who got tutoring as well as study materials got a first class last year. I suggest that you start tutoring as soon as possible if you are aiming to get high grades. If you want to be our next student to get high grades, you should join SimpleStudying as soon as possible. Thank you.